What are the requirements and the limits of responsibility for members of the armed forces to disobey unlawful orders? That's the subject of this episode of The Ancient Art of Modern Warfare. Welcome to The Ancient Art of Modern Warfare. I'm Chris Mayer, Colonel, U.S. Cavalry retired, and in this series I explain the enduring philosophy of war as it was, as it is, and will continue to be regardless of advances in weaponry or politics. Recently, there's been controversy over public statements from some politicians about the responsibility of members of the armed forces to disobey unlawful orders. In theory, there should be nothing objectionable about that. After all, members of the armed forces, from the lowest enlisted to the highest general or admiral, receive regular instruction on the laws and customs of war and our responsibilities under the Constitution. This instruction is repeated prior to each deployment, adding specific considerations regarding law and policy applicable to that mission. What concerns me is why these politicians felt that they needed to make such statements. One thought is that these statements were directed to the American people, who may not understand our commitment to following the Constitution and the laws and customs of war. It may sound archaic, but both the officers and enlisted personnel of our armed forces take our oaths seriously. Enlisted personnel swear to obey the orders of the President and the officers appointed over them. Officers, instead, swear to uphold and defend the Constitution. I say our because, as a retired officer, I am still subject to the Uniform Code of Military Justice and can be recalled and tried by court-martial for violating military law. There are some who propose that these statements by these politicians intend to promote distrust among our military personnel for our civilian military leadership. Since that would be very problematic, potentially seditious, as well as unlawful, I will presume that that is not their intent. Therefore, what follows presumes that these statements were directed towards the American people, with those politicians assuming ignorance of most Americans regarding the dedication and training of our armed forces. In explaining this, remember that I am not a lawyer, military or otherwise. What I am is a retired combat arms officer, the kind of person who would either issue or would have to follow orders on the battlefield. To begin, the idea that soldiers of any rank should carefully consider whether an order is or is not lawful before executing that order is ridiculous. In most cases, even lawyers and judges have different opinions from one another about almost any law. The 9 Supreme Court justices rarely all agree about the interpretation of law in cases before that court. It's unrealistic, therefore, to expect that any military person at any level to parse an order according to laws that may have different interpretations and different validity in different contexts, and only then to determine whether they should or should not follow that order. Military personnel of all ranks must presume that an order is lawful unless it is manifestly illegal. Without that presumption, almost any military operation would result in chaos. The issue, then, is at what point does an order become manifestly illegal? That was the question answered by the Nuremberg Tribunal when determining that obeying such orders was unacceptable. In an armed conflict, members of the armed forces are permitted to do many things that are otherwise manifestly illegal. These include killing enemy combatants and the willful destruction of property consistent with military requirements. Members of the armed forces are also immune from legal accountability for unintended deaths of civilians or destruction of civilian property when attacking a military target. Manifestly illegal in this context would, therefore, be acts outside of these permissions. These acts include what the Geneva Conventions term grave breaches and what the U.S. War Crimes Act of 1996 calls war crimes. The Geneva Conventions lists these breaches or war crimes as murder, torture, and extensive destruction or appropriation of property when directed against persons and property protected by the law of armed conflict and not justified by military necessity. Persons and property protected by the Geneva Conventions mostly means non-combatants. These are civilians not taking part in combat, the wounded, and prisoners of war. Protected property includes hospitals or other facilities for the care of the sick and the wounded, churches and other religious structures, cultural objects, and facilities containing inherently destructive forces like nuclear power stations. Even this list has allowances for military necessity. For example, if enemy forces violate the law of war by using a hospital to shoot from or to store military material there, then the hospital can be attacked. Wounded who continue to fight or otherwise participate in hostilities can also be attacked. In addition to the grave breaches described in the Geneva Conventions, other conventions covering the laws of war include prohibiting poisoned weapons, perfidy, declaring that no quarter will be given, weapons evil and of themselves, and compelling nationals to bear arms against their own country. Each of these prohibitions were also determined to be war crimes during the Nuremberg, Tokyo, and subsequent trials. Defendants in these trials did not question these prohibitions. Instead, they argued that the means and methods they used did not violate them. Sometimes the court agreed with the defendants, and rarely were the decisions by panels of judges unanimous. If the judges at war crimes trials cannot agree on specific acts, how can we demand that a soldier decide on his or her own whether an order is lawful or unlawful, especially during combat? It may come as a surprise to people who have not served in the armed forces, but when the situation allows, officers are encouraged to and will question orders. Now, this isn't a matter of questioning authority, it's a matter of ensuring that they clearly understand the commander's intent. This is most important when those orders seem to conflict with national or international law. But this type of question rarely arises. Commanders at senior levels have military lawyers on staff who review orders received and being prepared to ensure that they are consistent with the law of war or other relevant law. So, if an officer does raise that kind of question, it is almost always to clarify the commander's intent or how the means and methods to be used will comply with relevant law. But in most cases, the situation doesn't allow for those questions, and we must rely on prior training. This training includes classroom training and practical exercises where warfighters must make decisions about the limits of force. Military police receive special training in the law of war regarding prisoners. Military operations outside of armed conflict can be particularly problematic and incorporate specific training regarding the rules for the use of force applicable to the laws and authorities under which that mission is being performed. For example, I led U.S. military personnel during a United Nations peace enforcement operation in Africa. We were all well armed, but operated under rules for the use of force that were very different than the rules of engagement we had in Iraq. But what about the lawfulness of engaging in combat at all, questioning whether the order to initiate combat itself is unlawful or unjust? Within the just war theory, soldiers are allowed to presume that the war they are called on to fight is just. More important to the question of lawfulness or unlawfulness, this question was addressed by the subsequent Nuremberg trials, specifically the High Command trials. At that time, the tribunal considered each of the German generals and admirals accused of violating international treaties and waging aggressive war as not guilty. The tribunal reasoned that military officers were not the policymakers and that preparing for war and fighting a war on orders was not a criminal offense under applicable international law. On this charge, therefore, superior orders was a valid defense. But what if someone following an order performs an act that is afterwards charged as being unlawful? In this case, there will be an investigation, and if criminal charges are brought, court-martial proceedings under the Uniform Code of Military Justice. Under this process, a trial by a jury of their peers, the military police charged with mistreatment and torture of Iraqi prisoners of war at Abu Ghraib prison were found guilty. That they perceived the civilian contractors as ordering or authorizing that misconduct was not accepted as an excuse. In a different case, an officer who served under me in Africa later performed duty in another UN mission in the Caribbean. He was investigated for unauthorized use of deadly force during an incident there. I provided information to the inquiry regarding the training he received and the requirement not to follow orders that were contrary to our, that is, U.S. military, rules for the use of force. In this case, the inquiry found that he refused the command to open fire given by UN personnel, and the charges were dismissed. In summary, the members of our armed forces know what the laws and customs of war are as they apply to their conduct on the battlefield and their duty under the Uniform Code of Military Justice. They are also familiar with the specific laws and regulations that may apply to their mission. This requires them not to follow manifestly unlawful orders. It also requires them to follow the lawful orders of their superiors, and that they will be punished for not following orders that are lawful, even if the person refusing such orders believed them to be unlawful at the time. All military forces throughout history depended on soldiers and sailors to carry out their orders promptly and to the best of their ability. Recently, politicians interjected themselves into the good order and discipline of the armed forces. From my perspective, they strongly implied that members of our armed forces should refuse to follow orders that are not manifestly unlawful, but politically sensitive. These politicians will be unaccountable for the outcome of a military mission that may fail due to that refusal. They will also bear no responsibility should a member of our armed forces refuse to carry out what may be a lawful order. In my mind, whether intended as such or not, this may be considered incitement to mutiny.